Online at 560theanswer.com. Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft on AM 560. The Answer.
Top of the morning, Dan Proft here. Could we see an end to birthright citizenship coming? Supreme Court's taken up the case, Trump v. Washington. Donald Trump was making the case quite succinctly, actually, yesterday at that rally he had in Mount Pocono, Pennsylvania.
If you don't share our values, contribute to our economy, and assimilate into our society, then we don't want you in our country. We don't want you.
Okay. That's fair, in my view. Stephen Miller, his domestic policy advisor, provided a little bit more expansive perspective on the issue. Birthright citizenship is sort of embedded in the commentary he provided on the Will Cain show the other day.
During the civil rights era, and this is the simplest way I can put it, there was a thought in effect, if you go back and you can read the transcripts of the debate at the time, of applying civil rights to immigration policy for the globe, and to create a civil right for people from every part of the world to come to America in ever-growing numbers. And so a system that for years, as you mentioned, had been tightly restricted, suddenly established this global ability of people in every part of the world to come to America, to bring their families to America, and then eventually empty out their entire towns and their entire villages to the United States of America. And so what you saw between 1965 and today was the single largest experiment on a society, on a civilization that had ever been conducted in human history. Not just the 76 million immigrants that were brought in, largely from the third world, but their descendants too. So you see with a lot of these immigrant groups, not only is the first generation unsuccessful, again, Somalia is a clear example here, not only is the first generation unsuccessful, but you see persistent issues in every subsequent generation. So you see consistent high rates of welfare use, consistent high rates of criminal activity, consistent failures to assimilate. But this shouldn't be a surprise, Will. It's just common sense. If Somalians cannot make Somalia successful, why would we think that the track record would be any different in the United States? Go third world country by third world country. No one's saying, look, there are people all over the world that are great people. But you look at the society. If Libya keeps failing, if the Central African Republic keeps failing, if Somalia keeps failing, right? If these societies all over the world continue to fail, you have to ask yourself, if you bring those societies into our country and then give them unlimited free welfare, what do we think is going to happen? You're going to replicate the conditions that they left over and over and over again. And we mask the impact of immigration in every public policy issue we discuss. We talk about test scores. Well, if you subtract immigration out of test scores, all of a sudden our test scores skyrocket. If you subtract immigration out of health care, all of a sudden we don't have nearly the size of the health care challenges our country faces. If you subtract immigration out of public safety, all of a sudden we don't have violent crime in so many of our cities. Issue after issue, we talk about these things as if they just happen to us. The schools just suddenly fail. Violent crime just suddenly explodes. The deficit just suddenly skyrockets. These are a result of social policy choices that we made through immigration.
Yeah, I mean, there's a lot of truth in what Stephen Miller is saying. And look, I'm a proponent of legal immigration. I'm a proponent of, as I've mentioned so many times on the show, looking at it individual by individual. The point that Miller really is getting to is you can't do these things en masse. I mean, you have to have an understanding, and the point that Trump made as well, you have to have an understanding of who you're letting into the country and what your expectations are for them and what your assessment is in terms of what they are coming here to do. The assimilation piece, for example, the shared values piece, those are legitimate. and they are not race-based. You could have somebody from Somalia that wants to come here, and you are convinced that that individual will be a great American, and he is industrious, and he pledges allegiance to America, and he's ready to put on the uniform to fight for America, in Somalia even, if the situation warranted it. But it has to be done on an individual basis. And the abuse of all these programs that provided en masse status and a path ultimately to citizenship that he's describing, I mean, that has played out, not just here, but in Europe too. And thus this moment, with respect to birthright citizenship, which if the Supreme Court interpreted a particular phrase of the 14th Amendment in one direction, as opposed to the default direction at present, America will be charting a very different course going forward. For more on the topic, we're pleased to be joined by Morgan Marietta. He's a professor for the Institute of American Civics at the University of Tennessee, Knoxville. Morgan, thanks for joining us. Appreciate it.
Dan, thanks so much. Good to be with you. It is fascinating times at the Supreme Court these days with everything going on. Yeah,
it really is, and and it's such a emotionally, politically charged issue that some distinction and nuance needs to be brought to the discussion. We can do things like legal immigration. We can do things like be a beacon for political and religious refugees, but we have to do so in a sensible way. And I think it's very difficult to argue that we've been doing so in a sensible way over the last several generations, as Miller outlined, and thus this moment of birthright citizenship.
Yeah, what you were saying about the problems with assimilation and whether we do or don't have relatively open borders, that sort of question, when you take it to the Constitution, like on most things, the Constitution doesn't decide that for you. It doesn't make decisions. It lets the people do that themselves. It doesn't tell you what the decision is. It tells you who the decision maker is. Mm-hmm. And a lot of people think we should have open borders, and a lot of people think we should have relatively closed borders. But the Constitution doesn't decide it for us. What it says in the 14th Amendment is that it is up to Congress and the presidency. It's up to the representation of the American people. And that's how it's being pretty well misrepresented in most media discussion these days.
Well, and as it pertains to the case before the court, and we've talked about this with Professor Richard Epstein as well. You're probably familiar with his argument, but you're making the same one. The case, and because it has the potential to have momentous impact, really turns on how the court interprets the phrase "subject to the jurisdiction thereof" in the 14th Amendment, doesn't it?
Yeah, that's exactly right. People forget that this amendment, the 14th Amendment, this is a great amendment after the Civil War. The whole point of it was to equalize treatment of the free blacks. It was to equalize treatment by race in America. And they weren't really even thinking about illegal immigration the way that we think about it now. But they wanted a phrase that would let everyone know that anyone who was born here and who was rightfully here, who were the formerly enslaved people, that they would be persons and they would be citizens. And they, you can see in the debates about this, they weren't sure exactly what phrase to use because they were intentionally trying to not recognize the citizenship of Native Americans. It wasn't meant to be universal in any way. And they came up with this phrase. They said that anyone who was born in the United States and subject to the jurisdiction thereof, subject to the jurisdiction of the United States. And that's what that phrase, the debate, is all about, is about exactly what that means. And what we're seeing is this fascinating thing. I think there's two things going on. The one is that on the left, people are arguing that, oh, there's no debate at all. There's nothing to talk about here. It's just obvious. They're trying to really shut down any voice that disagrees with them. But of course, a lot of people disagree. There are a lot of constitutional law scholars who look at this in a reasonable, broad way, try to understand what the framers of the 14th were saying. And they disagree roundly. They pretend there is no debate, but there really, really is a debate on this. And the second thing, yeah,
go ahead. No, go ahead.
Well, there's it's fascinating to watch that how we understand the Constitution as a whole and how the Supreme Court interprets it has gone through this massive revolution in the last few years. The court has switched from reading the Constitution in a living way to reading it in an original way. So when you look at a phrase like under the jurisdiction of the United States, do you read it how we have come to think of it, or the evolving standards of the American people, or you sort of think in terms of polling? Or do you think in terms of what the people who wrote that, the people who ratified that, and this is from 1868, after the Civil War, what they really were doing? And if the Constitution is a contract between the American people and the government meant to limit the government, then the last thing you do is let people rewrite the words of a contract, especially the people who are holding the power in the contract. So you don't let the government, through the Supreme Court, rewrite what it means. It means what it meant at the time the people made that contract.
Well, right, and the historical context matters too. And in this birthright citizenship case, Wong Kim Ark, the Chinese immigrant in San Francisco, that's the subject of this case, is something that legal scholars point to. And Epstein, among others, makes the point that that case by Justice Horace Gray that allowed Wong Kim Ark to come back into the United States as a citizen misstated the prior law governing such an issue. He had left and he tried to come back.
Yeah, that's exactly right. Wong Kim Ark is an odd decision that's often misrepresented when people talk about this. It's kind of shocking. It's kind of shameful, really, how much people misrepresent that decision in scholarly discussion.
And I want you to address the misrepresentation, but it seems to me that if subject to the jurisdiction thereof is the key phrase in the 14th Amendment on which this case turns, Wong Kim Ark is going to be addressed. And the point that Epstein makes, which I think is a pretty good one, is that subject to the jurisdiction and within the jurisdiction were treated as synonyms when, in point of fact, they're antonyms.
Yeah. It doesn't mean just in the jurisdiction like contemporary people think of it. When you say that sort of someone's outside of a county sheriff's jurisdiction and therefore you can't touch them, like it's about geographic territory. It can't possibly mean that. The 14th Amendment says that persons born in the United States and subject to the jurisdiction. If it just meant geographic, it would just be repeating itself. It would be saying born in the United States and born in the United States. It has to mean something else. And it does. It means under the political allegiance and protection of the United States. In other words, it's a mutual agreement that someone has said publicly, I am desiring to be a resident and become a member of the United States, a citizen, meaning someone who has equal political control. What we're doing is we're deciding who gets to vote and who gets to have collective decision-making with us. And we don't just let anyone do that. You can't do that by your own demand. Like, Dan, you couldn't demand to be a French citizen.
Right.
The French get to decide that. And the intuition here is that it has to be mutual. A person publicly says they want to be a part of our community, a citizen, and we get to decide if they are or not. But that's what under the jurisdiction means. It means that you have been accepted as a member of the community. And that's what it always meant. And in the case of people who are here illegally, it clearly does not qualify with that mutual agreement. They are evading the authorities. They have not actually openly declared that they are under the laws of the United States. They're evading the laws of the United States. And the American people clearly have not accepted them as being under the jurisdiction. And the important thing to understand here is that people talk about Wong Kim Ark, and we can talk in a minute about why that decision really has not been honestly described. But there's another case called Elk v. Wilkins, and this was in the 1880s, about 15, 20 years after the 14th Amendment. And this was a case about a Native American who was suing for citizenship. And the court said very clearly that in the meaning of the 14th Amendment and how the American Constitution sovereign people, that means that an independent free people get to decide who is in their group. There's no such thing as citizenship by demand. Under the principles of the Declaration and then in the Constitution of the 14th, we get to decide. We have to grant consent. And that was the understanding of the 14th Amendment at that time. And by the way, Wong Kim Ark does not say anything different. It is presented as if what it said was that anyone who was born in the United States under the 14th is an automatic birthright citizen. That is not what it said. What it said was that Wong Kim Ark's parents were legal permanent residents. They had been given consent. They were in the United States legally, and domiciled in the United States is the legal phrase that's often used for that. If you even look up the case on oye.com, which is the website that many people use for these constitutional questions, and it keeps track of all the cases, they give the constitutional question, the question presented, as being, is the child of a legal permanent resident a citizen of the United States under the 14th? And the answer is yes. But it said nothing about people who were here illegally. Illegal immigration was not really on the radar at that time. And it does not say that. So the Supreme Court really does have to decide this for the very first time, whether the children of illegal migrants, or actually someone who is here for birth tourism. And that's the other part of the decision that people don't talk about a whole lot. It's about people who come here, often from China, just to have the baby, so that the baby has U.S. citizenship, and then they go back to China and have no connection to the United States of any kind. That was the other reason for the executive order that the Trump administration put into place. So it's also about temporary sojourners, is the phrase for that. Someone who's just visiting here in the United States. And neither one under the 14th have an automatic claim to birthright citizenship. We as a people have to decide if we're going to allow them to be citizens or not.
So how confident are you that Wong Kim Ark, at least as applied, goes the way of Plessy v. Ferguson and Roe v. Wade?
Well, I'm really not, is the thing. I'm not really confident at all. No, not at the current Supreme Court. There's an argument, you hear this a lot. It bothers me a great deal because I think it's kind of an insult that's in Wong Kim Ark. But a lot of people on the left buy it. But weirdly, a lot of people who think of themselves as originalists also buy this, even though it is not the original reading of the 14th at the time. And the argument pretty much goes like this. This is actually something that the 14th Amendment and the Constitution don't address directly. So you have to take the principles of it and then apply them to the contemporary problem, which is what originalism is all about. Often the Constitution doesn't tell you exactly. It tells you the principles, and then you apply the principles to the current problem. But what they did in Wong Kim Ark is they did actually have a discussion that tends to lead in the liberal direction on this, in the direction of birthright citizenship. Because what they said, they asked the question, what is the common law, especially the old British common law? And when we declared ourselves independent, we still needed law. We brought over the British common law, and then we adapted it to American purposes. But what we explicitly did is say that the parts of the British common law that don't make sense anymore under American independence and American principles of natural law and rights and free people just simply don't apply anymore. But what they did in Wong Kim Ark is they took the old British common law rule, and the British common law rule was that the subjects of the king, and they weren't talking about citizens, they were talking about subjects. If anyone was born on British soil, the king declared them a subject. And there were very few exceptions to that. But it's pretty easy to understand why. The king wanted cannon fodder. He wanted as many soldiers as he could get. The king wanted as many subjects as he could get to increase his own power. And that's because those subjects had no claim on him. They didn't have rights. They weren't supported by the government. The king wanted anybody he could get. But when we became citizens rather than subjects, that's a completely different thing. It's not the king seizing people for his own benefit. It's citizens who get to decide who else are democratic decision makers along with them. And everything changed after the Declaration. So it's really insulting to the American project, actually, to say that British common law of kings and subjects comes over. And so I really hate it when people make that argument because it makes no sense. But what they say, even though it's wrong, is that under British common law, which they say we should accept, which we should not, that there were only very few exceptions to birthright citizenship. Well, one of them was if you're an ambassador's kid, and another one was if you were the kid of an invading army. So they think that those are the only exceptions, but that is not what they meant by subject to the jurisdiction of the United States.
Yeah, well, I mean, actually, Epstein, in his argument against birthright citizenship, addresses that in part by referencing Blackstone's writings on the topic, too.
Yeah, that's right.
Which support the claim that you're making.
Yeah. If you look at what people thought at that time, if you go back to Blackstone even earlier, but if you look at the legal treatises of the time, if you look at the popular discussion at the time, most importantly, if you look at what the congressmen, and especially the senators, when Jacob Howard, the senator, introduced the 14th Amendment and talked about it and explained it, he explains very clearly, this is all in the record, of what it meant and what it was attempting to achieve. And it was not about these British common law exceptions alone. It was about this broader idea that you had to have mutual allegiance, that if you were accepted by the United States based on our consent, and you were here legally, and we had granted this kind of membership, then of course your kids are citizens, but not otherwise. So the problem is that so many people were taught in law school, and it's been repeated so many different times, this misrepresentation of what Wong Kim Ark said, that it applied very broadly, and that the British common law is obviously the way to understand it, that some originalists have decided that originalism means reaching back into the history, back to the British common law, instead of looking at the original meaning, the public understanding, what the authors said at the time of the 14th. Originalism means you look at the authors and ratifiers, the original public meaning at that time, not to go back into antiquity. So people have been tricked by this, I think. And to answer your question, the three liberals are very much going to rule against birthright citizenship. Oh, no, but in favor of automatic birthright citizenship. Of course. And against the Trump administration. The problem is that I don't have a lot of confidence that the alleged originalists on the bench will actually have the courage, really. I think it's a matter of courage. You have to stand up to people who say, oh, you sound mean. You sound like you're being heartless. And again, the Constitution doesn't decide what's mean and what's heartless. It decides who gets to make the decision. And the decision has not already been made. It's up to what the American people think, how we think about assimilation, how we think about what proportion of the country should be foreign-born, and how much time we want to give for assimilation, and how we handle immigration. It is fully up to the Congress to decide to whom we grant living under the jurisdiction and being a birthright citizen.
Well, we're going to find out.
What's going to happen is that John Roberts, I think, may well side with the liberals. I think that Kavanaugh might also. Barrett might also. So they only need two of the originalists to come over, and they might get a 5-4 or even a 6-3 decision out of it. So I don't have a firm prediction on it, but I'm afraid what's going to happen is that a couple of the Republican appointees will not have the courage to follow the original meaning of the Constitution, and they will side with the liberals on this. But I expect a deeply split decision.
Hopefully we'll be pleasantly surprised with an exhibition of courage, particularly from Roberts and Barrett. We'll see. Morgan Marietta, professor for the Institute for American Civics at the University of Tennessee, Knoxville. Morgan, thanks for joining us again. Appreciate it.
Thanks so much. Take care.
Take care. And Morgan Marietta, join us on the Turnkey.Pro answer line. Let's check the headlines.